Traditionally dominated by men, the Indian legal profession saw the gradual inclusion of women through prolonged legal battles. This was because the Legal Practitioners Act of 1879, as it stood then, did not recognize women as persons. A woman was not eligible for a certificate under the Legal Practitioners Act to function as a pleader due to her gender. But the passage of the Legal Practitioners Women Act helped women to gain a foothold in the profession. However, 100 years later, the ground statistics and realities are far from encouraging. The representation of women in the bar and on the bench has become an important topic as the legal landscape in India evolves. Over the years, women have increasingly taken on significant roles as lawyers, judges, and legal scholars, despite facing historical challenges that have often sidelined their contributions. Bar associations serve as professional bodies for advocates and play a vital role in the administration of justice. The Bar Council of India, along with these bar associations, acts as a key stakeholder in safeguarding the rights of advocates and driving positive change within the legal community. While the bar evaluates judges and its members through networking, it is evident from historical analysis that women lawyers have been underrepresented in the electoral processes of bar associations. Today we explore the significance of women's representation in these bar associations and the implications for the legal profession as a whole. Traditionally dominated by men, the Indian legal profession saw the gradual inclusion of women through prolonged legal battles. The early 20th century marked a turning point with the Legal Practitioners Women Act granting women the right to practice law. Before the passing of the Legal Practitioners Women Act, women in India were not allowed to practice law. They were only allowed to study law. This was because the Legal Practitioners Act of 1879, as it stood then, did not recognize women as persons to be enrolled as pleaders and wholly excluded the entry of women into the legal profession. The right of women to practice law was granted after legal battles. In numerous instances, courts were of the view that women were not persons for the purposes of entering the legal profession. The first woman lawyer's case was that of Rajina Guha. After acquiring a bachelor's degree, Rajina Guha submitted an application to be admitted to the Alipore District Court as a pleader. The court considered the application. Rajina argued that since the General Clauses Act interprets the words importing masculine gender shall also be construed to include females, that is, when the statute says man, it includes woman. Now the Practitioners Act regulations, despite referring to men in terms and despite the argument that it would include women, the bench finally decided that a woman cannot be enrolled as a pleader. The bench opined that at the time the Legal Practitioners Act was promulgated and passed, there had never been a case of a woman being permitted to practice law in Indian courts, and the Legal Practitioners Act made no mention of female attorneys, was the logic. The second instance was that of Sudhanshu Bala Hazra, another woman lawyer who submitted an application to the Calcutta University first requesting permission to participate for the preliminary examination of law as a private candidate. Her application was initially denied because she had not regularly attended law lectures. But finally, the Calcutta University granted her permission to take the preliminary law examinations as a private candidate. After earning a bachelor's degree in law from Calcutta University in 1921, she made an application to the district judge of Patna to be enrolled as a pleader. The application was forwarded by the district judge to the High Court according to the practice that prevailed. So, the Patna High Court upheld the position in Rajina Guha's case that despite the provisions of the General Clauses Act of 1868 and 1897, a woman was not eligible for a certificate under the Legal Practitioners Act to function as a pleader due to her gender. But in the meanwhile, in England, the Sex Disqualification Removal Act of 1919 had been passed, allowing for women to pursue the legal field. Concurrently, the Allahabad High Court authorized Cornelia Sorabji's enrollment as a vakil. On 21st of August 1921, the Allahabad High Court took lead and allowed the application of Cornelia Sorabji to enroll as a vakil. She hence became the first woman advocate of India. Considering the decision of Allahabad High Court and the favorable observations in Sudhanshu Hazra's case by the Patna High Court, a concerted effort to amend the Legal Practitioners Act was launched that yielded results finally. In 1922, Narayan Malhar Joshi introduced a resolution to amend the Legislative Assembly electoral rules to remove sex-based disqualification in the matter of voter registration. The Legal Practitioners Women Act was passed finally in 1923, removing the disqualification and stating that no woman shall be disqualified from being admitted or enrolled as a legal practitioner or from practicing as such solely on the basis of her gender. Although a century ago, a court ruling reversed the ban on women practicing law in India. That is, as of 1923, women were barred from practicing law, but the passage of the Legal Practitioners Women Act helped women to gain a foothold in the profession. However, 100 years later, the ground statistics and realities are far from encouraging. Parliamentary data presented in 2023 by the Law Minister showed a wide gap between men and women, not only in terms of judges but also in terms of practicing lawyers. As of January 31, 2023, there were 2,84,507 women lawyers out of a total of 15,42,855 registered advocates in the country, which is about 15.31%. Since 1990, the Supreme Court of India has appointed 11 women judges. In the High Courts, out of about 1,108 sanctioned strength, 775 judges are currently working, including 106 women judges. This means that women judges make up a small 9.5% of the total judges' strength and a small 13.6% of those currently serving in the High Courts. As the percentage of women advocates in India is just 15.31%, they constitute a minority in the legal profession. In other words, the data also pointed to the fact that the legal profession is still predominantly male-dominated. As the number of women lawyers is very less, they do not get elected to key positions in bar associations. The Delhi High Court Bar Association had a woman president way back in 1962. It has been more than 60 years and the Delhi High Court Bar Association has not had a woman president. Reservation for women in bar associations too has been negligible. The Supreme Court of India, in the case of SCBA, that's the Supreme Court Bar Association versus B.D. Kaushik, held that 1/3 of the positions in the SCBA must be reserved for women to ensure their fair representation. Following the decision in B.D. Kaushik, others sought similar change for the Delhi High Court Bar Association. In Fozia Rahman versus Bar Council of Delhi, the Supreme Court ruled that 3 posts for women lawyers must be reserved in the elections of the Delhi High Court Bar Association. Furthermore, in the district bar associations, the court mandated that the treasurer's position and 30% of other executive committee roles must be reserved for women lawyers. In D.K. Sharma versus Bar Council of Delhi, the Supreme Court also extended women's reservation to the National Green Tribunal Bar. Now, why should greater representation be given? There are scarcely any profession where women have not faced discrimination irrespective of the stage of their professional journey. From the inception of their career, as they progress in their respective careers, disparities based on gender remain. When they pass these obstacles, they eventually face the glass ceiling, which can be said to be invisible but is a real barrier that stops them from reaching the apex point in their professions. This glass ceiling prevents a large number of female lawyers from attaining important positions and particularly bar representative positions. As a profession, litigation requires time, effort and commitment. In India, women unfortunately are forced to adopt different roles and they have to role play. Bearing household tasks and child rearing duties, the ability to manage both domestic and professional space becomes troublesome. The notion of women shouldering dual roles, both as caretakers of the household and as professionals, is not limited to the Indian context alone. This delicate balancing of responsibility frequently imposes a disproportionate burden on women, resulting in what is commonly referred to as maternal penalty, wherein their professional progression is impeded by the societal expectations and obligations associated with motherhood. Considering the dual role that women often bound to carry in her life, a support should necessarily be given to achieve equality of opportunity in the legal profession. A concerted effort to be put in by the bar and the bench to achieve this equality of opportunity is absolutely necessary. Ensuring minimum women representation on the bench and in bar associations and in key legal postings can help in bridging this gap and thereby ensuring that women lawyers have crossed the glass ceiling. The introduction of reservations of women in the Supreme Court Bar Association elections can be regarded as a significant measure aimed at addressing the prevalent gender disparity within the legal associations and the legal profession at large. By ensuring a certain percentage of seats being reserved for women, there is an opportunity to promote greater gender diversity within the leadership of the Supreme Court Bar Association and other bar associations across the country. But there are also questions being raised about whether 77 years post-independence, reservation is still the most effective tool for positive discrimination. The concept of reservation at times serves as a double-edged sword, sparking ongoing debate within the Indian socio-political landscape. Globally, the issue of women's representation remains unresolved. The recent pilot project of the Supreme Court could shed light to the efficacy of affirmative action measures. Reservations to certain posts of the Bar Association would help to increase and make sure that minimum representation of women in bar associations occur. As data quoted shows that only 15% of the entire legal community constitutes women, an enabling provision is absolutely necessary to ensure minimum representation of women in bar associations. This would help in addressing the systemic barriers that hinder women from fully participating and advancing in their decision making of bar association. It can also serve as a medium to amplify women's voices within the bar, leading to a more inclusive decision-making process and policies that better reflect the need and perspectives of all members.